we're on.
Okay, we're good?
Yes.
Okay, so I hereby call this Orange Township Zoning Commission meeting of Tuesday, March 18th to order. Can we please have roll?
Mr. McNulty?
Here.
Mr. Bellis?
Here.
Mr. Pierce?
Here.
Ms. Foster?
Here.
Ms. Sundar?
Here. All right, so I understand our meeting is scheduled to go over our zoning code amendment or our zoning code rewrite. So Robin, can you please walk us through the process?
Sure. Thanks everybody for being here tonight. We are continuing discussion on our zoning code update. So we've gone through the first 5 articles of the draft code so far, and we are going to plow forward. We'll try to get at least through articles 6 through 10. So these are the actual districts and zones. So some of them will be new zones, new districts that we're putting into place. Some will be edits to existing districts, but I'll go through each one as it comes. We will start with Article 6, which is the Lewis Center Village Overlay District. So some background on this. We have this set up as an overlay currently. So to remind everyone, an overlay district is basically an opt-in zoning. Almost all of the lots in Lewis Center Village currently are zoned FR1 or farm residential. So what we're suggesting is to put into place an overlay district where the base zoning stays as farm residential until the property owner requests that the overlay district be applied to their property. And then it would have a different set of standards that would apply to their property, and they would, in theory, be allowed to pursue a project pending approval. So we have currently, we have an overlay district in our current code, which is the Route 23 Corridor Overlay District. We have this theoretical Lewis Center Village District set up slightly differently in terms of process. So the way we have it set up is that the zoning commission, meaning you all, would actually approve applications for the overlay district for the Lewis Center Village. And so there's various reasons for this. And I'll kind of get into this. It's a difficult area in terms of planning and zoning. Michelle, are you able to pull up the auditor's website real quick, please? So just to be clear, and we do have the actual map of the included parcels in the draft code, but you can see most of the lots in here are very small, and they're actually way too small for the current zoning, which is farm residential, which is designed to be the large lot, rural type of zoning district that we have. This was an older subdivision that was platted well before our current zoning regulations came into place, but they just always have stayed farm residential. So it's difficult because we want to strike a balance between allowing property owners in this area to be able to build homes, to add on to their homes, when it makes sense. But currently they can't do that without a slew of variances. So there's one house that was built there within the last, well, I think it's currently under construction, but was approved 2 or 3 years ago. I think they got 13 variances from the Board of Zoning Appeals in order to build that. So it's just very tricky to make it work with current legislation. And it can be onerous on those property owners to have to go through that process in order to do really anything, because the lots are just too small for the zoning as it stands today. So it's a difficult, I'd say a difficult policy conundrum as well, because if you look at the size of these lots, it may or may not make sense to have one house on each one of those tiny lots, or you'd end up with 30, 60 tiny homes.
Do you know on an average how wide those lots are?
Like 20.
Yeah, 25, 30 feet.
Yeah.
Okay.
I can tell you that. It looks like from the
Can you
map.
stand up, speak your name, address, and let us know?
Sorry, I didn't mean to interrupt.
Oh, no.
I have 18
The smallest, my name is Nick McCoy. I'm a 22-year resident of the village. That's what we call it, the village. At 1201 Franklin Street. My wife also owns property at 1184 Franklin Street, and we're about to own 3 lots next to 1184 Franklin Street on Friday. To answer your question, the smallest lot in the village is, one thing I want to point out, that's the auditor's picture. I'm also an attorney, and in full disclosure, I'm also on the Board of Zoning Appeals, but I'm here in my personal capacity. The auditor's picture is a little bit misleading in terms of showing you how many lots are there. There's actually way more lots than that auditor's picture shows. It shows ours at 1201 Franklin Street as one big lot. It's actually 6 separate lots that are 35 feet wide by 120 feet deep. The smallest lot in the village is 34 feet wide by 108 and a half feet deep. So 3,680 and a half square feet. That's the smallest one. On average, you're looking at most of them being 35 foot wide. That's sort of kind of what they settled on many of them is 35 feet on a width. And then you have 115 feet deep, you have 118 feet deep, and you have 120 feet deep on each of those lots. But when the auditor gets a hold of something like our property, they put a parcel number on something, and depending on when it happened between 1860 and 2025, at one point, our house was, in its legal description, which is how it's transferred, is lot 79, 80, 81, 82, 83, 84. But when a parcel was created at some point, they combined all 6 of those individual lots. And that's what's happened on a lot of these. If you look at the old picture of the original plat, you can't hardly read this one. I have another one from 1973 where they vacated a bunch of alleys in there. It's a little bit more readable. But this shows you that there, at one time, larger lots were east of the railroad tracks. And there were only 2 larger lots. One was a school lot that they had platted out, and one was a church lot. And ironically, the school lot is 70 feet wide by 115 feet deep, so 2 lots wide. And then the church lot, they gave more room for the church. I guess they wanted 3 lots there, so it's 105 feet wide. But these pictures give you a better indication of the actual little lots that are there. I can talk later, but I'll let you go on. I just wanted to answer that question.
Thanks.
Thank you.
It looks to me from the picture that the population may have decreased. I mean, I could be wrong, but just in the quantity of houses and buildings, and you may know more to that as to what's taken place.
It's pretty full right now, and like Robin pointed out, there's been one new
Nick, I'm sorry, in order for me to capture you on the recording, I need you to
And
please.
like Robin pointed out, there's been one new build there in the 22 years that we've lived there. There was another new build, but what they did is they tore down their existing house and they built a new house right where it was. They actually lived in a trailer on the property for quite a while, and that was way back when we first moved there. Our concern, and I can get into this later when you get into the numbers, my concern, I absolutely 100% agree that the farm residential designation for the village makes it impossible to build a doghouse on these lots. Because I can't remember the exact numbers for the setbacks, but like I said, my lot, our house is 120 feet deep. But it has like, oh, your front setback needs to be 60 feet, your back setback needs to be 60 feet. Well, guess what? You have 0
Your house
feet to
disappears.
build on. You can't build a house. The other confusing thing is needing a variance between 2 contiguously owned lots. So if I own 2 lots, I gotta get a variance for building across the lot line in between the 2 because the setbacks are something. So I agree with that modification. My concern with the numbers that are used in what is proposed is consistent with what Robin said, but also contrary to what he said, that you, given those numbers, 6-foot side yard setback, 10-foot front yard setback, 20-foot backyard setback, guess what you could have? You could have, I could own 3 lots, which I am purchasing on Friday, and I can build 3 houses, lot. And they're gonna be 3 houses that are basically similar to these townhouses, condominium rentals that they're building at the Greenery or the Marigold project across Green Meadows from the village, or even similar, even though the lots are wider, to like Evans Farm. So you say 6-foot side yard setback, okay, now what do I have? House, I got 12 feet between 2 houses. Guess what Marigold is? 12 feet. 12 feet between their townhouses. In the village, we don't have sewage. So to open that up, to be able to build that, you would have to have sewage come into the village, which, from conversations I've had with the villagers, I'm sorry to use that term, it's like we have pitchforks running around, but we can get that way, is there's like, oh yeah, it would be nice to have sewage. There's always a charge, you know, $15,000 or whatever it is when you have sewage put in. But there's a lot of opposition to having sewage come into the village for the simple fact that if you change the zoning code and you say 6-foot setbacks from the side, now you have a developer come in, buy 3 lots, and they put 3 houses that are now what I term, based on your current zoning code, and whether these words are actually in the current zoning code or not, or maybe I've interpreted them to be in there, is now you have houses being built by someone in the village that aren't complementary to or consistent with what is already in the village. And that's very important to the people that live in the village, that if you're going to build there, you shouldn't have to get 13 different variances. But if you want to build closer than, let's say, 15 feet to an adjacent property owner, you want to go to 10 feet or you want to go to 6 feet away from that adjacent property owner, then you, as the person wanting to build that, should be forced to come to a Board of Zoning Appeals and get a variance with notice to your next door neighbors, those adjacent property owners, to have them have the opportunity to come in and argue and say, hey, that's a little too close given certain circumstances. So when I'm here, you know, arguing about numbers, I'm frankly, based on what we own, I'm arguing against my own best interest. I told you I would be. Because by owning, we own 8 lots across from us, we're about ready to buy 3 other ones. Theoretically, if sewage came across and we didn't have to have septic, that's the whole thing about sewage, needing sewage. Because if you have to have a septic, you're limited on area that you could have anyway. Theoretically, I could tear down the big barn and say, hey, sorry about you other villagers, I'm gonna build 11 houses. And then I'm gonna move to Florida and I'm gonna rent them out and leave you guys here to deal with it. And I'm not for that because I've been there for 22 years. So I think my request for this committee is the setbacks. I totally agree with the zero setback in between adjacently owned properties by the same property owner. So if I own 3 lots in a row, I shouldn't have to get a variance to cross the 3 lots to build. But the setback from my neighbor should be more than 6 feet. And that eliminates that small lot and the ability to build a small house on it and a townhouse type structure. Because I think the other numbers are 6-foot setback from the side, 10-foot setback from the front, 20-foot setback from the rear, up to 35 feet tall. What do you have? You got Marigold, you've got the Greenery, you've got those kind of builds in the village, which none of them exist. Some might point out that if you go more towards the east in the village, you do have properties that would be built within 15 feet of a side yard setback. Maybe even get as close as 6 feet is what is being proposed. However, I will point out that those are almost grandfathered properties, not by any letter of the zoning code that says they're grandfathered. But if something happened to one of those individuals' houses, let's say their house burnt down, or it got destroyed by a storm or something like that, yeah, they would have to come and get a variance. But I think my understanding of the law, and basically just the law of equity, is I couldn't tell somebody from a legal standpoint, because I think they'd win in court, especially if you asked for a jury and you said, hey, jury, I want to build exactly what got destroyed in the fire. But yet Orange Township's telling me I can't do it because it doesn't fit their zoning code, that they modified way after the fact that I had that house, I purchased that house. I think those properties are pretty much grandfathered in, that if they are up that close, then they could rebuild to the extent that they were already that close. My big concern is about lots that I own, lots that somebody might purchase, lots that, I hate to say, a developer comes in and says, I'm gonna give you, they changed the zoning code, I can build multiple townhouses on your guys' area of the village, and I'm gonna buy you guys out, I'm gonna tear all your houses down, and I'm gonna build 20, 35-foot lot houses and put them up there. I'm gonna pay to get sewage to come across Green Meadows Drive. I'm gonna pay to get sewage to come from the rear, the old Kerbler property, and what's being developed back there, versus the people that have been there a long time. This village goes clear back to 1860, I think is what this map is. They vacated a bunch of alleys and some roads that they had inside of it, but the railroad tracks through there, rumor is that after Lincoln died, he may have come through one of those railroad tracks through that place. There used to be a railroad stop there. There's still a structure, if you go through the village, there's like a little wooden tower in somebody's side yard that was there from eons ago for the railroad. It is, I can't say for certain, but in Orange Township, it's gotta be one of the oldest developments and settlements. And I think that uniqueness of it needs, I would ask, and I think a lot of people that live in the village would ask that that be protected in some way. That if you want to change that uniqueness about that property, about that area, that village, that you have to come and your neighbors then are given a lot more due process to come in and argue against something that you're trying to do that would change the uniqueness of that area. So
I'm wondering what the long-term impact of Evans Farms is going to be, and the additional traffic of the ball field,
Yep.
and all of that. I hear what you're saying. If this were sitting in farmland, preserving it would make more sense.
Yep.
As you look at this today and the future and what's there, it's that, yeah, I appreciate that, I do, but, that's why I was asking about what the population was, because it would be easier for everybody, yeah, again, once everybody's gone, to try to bring this up to 2025 standards rather than 1860 standards where it sits. Because you're right, the complexity of this and all the variances and the size of the lots by today's properties just get to be near impossible.
I can answer your question a little bit. At one point, years ago, we raised 3 children there. The youngest was still at home and in high school. At one point, I think it had dwindled down to there was probably, because the schools, every time they would redistrict, for some reason, they like to pick on the village of Lewis Center. They wanted to redistrict right with the railroad tracks. So you're gonna take this little village and you're gonna separate any kids that live on the east side of the railroad track versus any kids that live on the west side of the railroad track. And multiple times, even before we were there 22 years ago, there was it had to be pointed out to Olentangy's school system that, hey, don't break up the village. You're talking about 5 kids. 5 kids at that time. In recent years, probably the last 6 or 8 years, we've got families that are replacing the older families that lived in the village, and they have young kids. The Veers moved out. We bought the barn area, the lots, and we're buying 3 more lots off of them on Friday. They moved out and they sold their house to a young couple that have two little girls. And then we've got more kids going through the village. So I don't know the numbers exactly for you, sir, but it has gotten, the demographics have gotten a lot younger. It's kind of, it got old, and then the older ones, ironically with what you were talking about with Evans Farm and the Jennings Sports Park and everything else, the older ones said, we're out of here. And when they did, younger families came in. Because some of these houses in this village, maybe they couldn't afford to buy an Evans Farm or they couldn't afford to buy somewhere else. They bought in the village with their young kids.
Affordable, right? No.
Yeah. So we got old since we moved in, and then we got a lot younger in the past 6 to 8 years. So there's a lot more kids in our neighborhoods.
And that's our dilemma, but you've already seen that, is
Yep.
how to write this to where it makes some sense, so you don't have to have 25 variations to build something. That's of
Exactly.
no value to anyone.
And I agree, I completely agree with you. I think we're going from one extreme of you can't build anything to another extreme that says you can build whatever you want.
Yeah, but you also raised a valid point, is that this is an area that is still somewhat affordable.
Yes,
That someone could buy a property, either with a house or without a house, and might be able to put an affordable house as opposed to
Yeah.
Evans Farm or someplace else like that. So I would like to keep that opportunity open for people. But I also agree, I don't want to see it maximized. I wanted to keep its, I won't say historic character. So the question is, how do we do that?
yeah. And how you find that fine balance between the two?
How much restrictions could be written into the code as to what type of structure was there? You know, either dimensionally or materials, because it almost has to be that way. I mean, I know what you're saying, you bought 3 lots and they built across them, and I'm
Yeah.
gonna keep the setbacks
I
on
mean,
one side.
even the
to other.
even the standards that we're recommending, there will still be some legally non-compliant homes. Something the board can consider is maybe having a larger setback for the primary residence, and then having a smaller one for accessories. Like, a deck has to get like 10 divergences. You know, if you want to build a deck, you have to get 10 divergences.
I'm glad you brought that up, because I was
So-
gonna mention that. So your living residence has a larger setback than a shed.
Yeah, so that's
than a
something you
patio,
guys can
things like
consider.
that. Because, but what ended up trying to happen last July, I came into the board, this was before I was on the Board of Zoning Appeals. It's actually how I got interested in being on it. I came in and argued at a proposed sale of 6 lots, 3 of which I'm buying on Friday, to a couple that wanted to build. The barn we own there that we bought from the Veers is 64 feet wide by 80 feet. No, it's 80 feet wide by 64 feet deep. It covers over 3 lots, and it's a barn. It covers over 3 lots, but it sits on 4 lots across. Somebody was trying to buy 3 lots and 3 lots and put a house, the dimensions, the footprint of the barn, and 5 feet taller than the barn, across 3 lots. And I'm like, whoa, wait. That's, you're picking the wrong area to build your McMansion. And the only thing that saved it was an area variance and convincing the Board of Zoning Appeals that you were changing the uniqueness of the village, and what they were trying to build wasn't consistent with or complementary to anything else being built there. And the area variance is literally what shot it down. Because and it was only because of the area variance, because it was farm residential zoned. Now, you go a year later, you approve this drop down, which who's not gonna pick the drop down? I can't build a house, or I petition to pull down this overlay. Well, I'm gonna petition to pull down the overlay. Now the onus, the burden shifts to the current landowners there to come in and argue against something that is arguably permissible to be built, because they pulled down the overlay and the setbacks are so small. What's your argument? other than, you know, I really just don't want the McMansion there, and it's not consistent with everything else being built. But you don't have the numbers to back up saying, no, you can't build that. It's a difficult thing to do.
I almost think we have to write this around some restrictions, and this is the Lewis Center overlay, and
Yep.
here's the restrictions you've got to adhere to, or you can't build here. You just, and make it a real strict thing within, say, hey, and I'm not sure where that goes, I'm not educated enough to draw all that and decide what it should be, but.
I have some ideas.
But it needs to be something direct like that to avoid the divergences
Yep.
and to keep the character of this intact.
Yep.
And not allow somebody to buy 4 lots and put a giant mansion on it, it wouldn't be allowed.
Yep.
And zoning commission members, if I can give some additional context. So and this is not, obviously Lewis Center Village is unique, but we are starting to see more and more similar situations pop up, whereas a very old platted area, still individual lots that are non-conforming because they don't meet the size requirements of the existing districts, but, and I know we've talked about non-conformances and that type of thing. Your zoning resolution, contemplates how to handle non-conforming lots and that type of thing. And just to give some of the policy and practical items that I know Robin had chatted about, and obviously the concerns of the folks who live in the village. Ohio law does not favor rendering property useless. And obviously, in the situations we're talking, or a lot of the focus has been on someone buying three multiple lots, building something very large that doesn't necessarily meet the size. Theoretically though, and I've seen, and not in Orange, but in other communities, again, very similar size lots, someone comes in and buys one little lot. And they say, I want to build a small little house on it. And the law does not favor, again, rendering someone's house useless. And the law permits nonconformities to be addressed, even though it doesn't fit the size and standard and that sort of thing. And that's, again, now they come to your BZA and ask for a variety of variances. And what Robin and I have talked about is there could be a scenario where if someone were to buy and wanted to build individual lots, say from a legal perspective, you're gonna render their property useless. I do think and this is where, again, zoning world and the Venn diagram of all the other restrictions, I do think there are other places where maybe zoning doesn't limit how dense this could be. Again, septic is a prime example. If you can't put a leach field, if you need a leach field, you can't put a leach field on the size lot, you can't do it. In terms of, I'm guessing you guys have wells as well.
No,
Wells
we
as
have
well.
Delco water.
So you do have Delco water, okay. But in terms of stormwater drainage and that sort of thing, there are other areas that deal with restrictions, but just at a fundamental level. And again, the overlay, I know that, as Robin said, the overlay was considered to try to help folks not have to get 1,000 different variances. But in terms of just globally, if the if the overlay does not move forward, and kind of the status quo continues, just as a policy, just a global legal perspective, it doesn't necessarily prevent someone from coming in. Again, as he said, they would have to go to the BZA. It does provide the neighbors the opportunity to voice their opinions and that sort of thing. But just from an overall legal perspective with non-conforming lots, and again, the law disfavoring rendering someone's property completely useless. Just wanted to at least give that additional context.
Yeah, and how we're proposing it is a public hearing still.
Yes.
So anything that anyone builds, it's just a different, it goes to the zoning commission. Is it considered more of a judicial process because it's
It would be
overlay?
administrative
Or
because
administrative,
of the overlay.
yeah. So similar to like how the BZA would
Yes.
handle it?
Yep.
Yeah, so that's something to.
All right, I mean, as a preservation planner, there are a lot of areas that I've worked in like Dublin or Old Westville, things like that, and they do have guidelines to to try to keep the historic character, realizing that there's going to be infill. And usually it's adjusted to, like, the setbacks would be looking at the existing setbacks and looking at an average, or somewhere in that average is where you're allowed to have the setback. Your heights are the same way. Somewhere in that average is your height. Somewhere in that average can be your width or your setbacks. So,
Yeah, I mean, as far as sorry, Christine, as far as the average goes, it's hard to do that because a lot of the homes are really on top of the property lines. So,
And they're across 2 and 3 property lines, so what do you take as an average, because there isn't one, even as you see
Yeah,
the pictures.
and so I think Mr. McCoy kind of referenced this, but you can see on the screen there, even though the homes are right on the property lines as they're drawn today, the homes are at least separated from one another. And so I think what the solution could be, and
yeah, like a building separation.
yeah, that could be one option, or, as Mr. McCoy had referenced earlier, that there can be one setback for a structure to a property line with an exception for cross-property structures.
That was Michelle. I just jumped on it and said, yes.
That's an idea.
So so that means if you have a building that straddles multiple property lines, then that setback is functionally 0.
so the question I have is, if you have a building that straddles most 2 property lines, how come those lots were never combined? Don't they have to be combined in terms of, property and ownership?
It does strike me as odd that that the auditor's office has combined some lots and not all. I think that's probably just a matter of the age of, I have no idea how old some of the, how old are some of the older homes in the community. Frankly, some of the property owners could contact the auditor's office. There's a pretty simple process for getting your parcels combined.
Well, see, and that's what I thought. I thought as like, if I am buying 3 lots and building a house on those 3 lots, I have to combine them.
I mean, I think
That's
in
what I've always had to do
today's
as an
world,
architect
I
with
think
my clients.
today's world you do.
Okay,
So-
thank you.
Yeah.
Well, and I can actually contradict that a little bit, because Michelle, right where you're, just north of there, so that's where that home is, that's the new build. And they came in for the BZA 2 years ago, and they got those variances, which included 0 setback for the middle property. And they got their variances, and we approved the zoning permit accordingly, even though it is
And
across.
the county never made them
No.
combined?
And-
Okay, because if I have to do something in the city of Columbus, it has to be combined.
Yeah.
Because the auditor is different than the
Franklin County,
legal
yes.
description.
Okay.
So the auditor combining lots to say it's, okay, that's one parcel, that's one PIN number versus 3 different PIN numbers. That's up to the auditor, but when the legal description is written, which controls how property is transferred, it's still lot 88, 89, 90, 91. As of the White Sulphur addition to the town of Lewis Center, way back then when they planned out of town. So if you go to the left, if you go to the west on that, for some reason where the barn is, okay, they made that long parcel there, one parcel. That's 4 different lots with a vacated alley through the center of it. Ours, north of that is 6 different lots, but they made it one parcel number. It's like, that's 6 lots, 6 35-foot by 120 feet lots with one parcel number. I don't know why, I don't understand the hows or whys of that. I'm dealing with it now about the vacated alleys with the property description of the transfer, because they vacated a 15.5-foot alley. By default, when that alley is vacated, 7 3/4 feet goes to the lots over here, and 7 3/4 feet go to the lots over here. No one split it up. So we have we have 3 lots that were sold, and in the property description it says, in the legal description for the deed, it says, lots 88, 89, and 90. In addition to that, any and all interest that the grantor owned in the vacated alley now goes. That's incorrect. Because one common owner owned all 6 lots. They sold these 3 with a vacated alley in between them. Half of that vacated alley goes with those 3 lots. That's incorrect. That's an incorrect legal description that they have to figure out now when I buy these other 3 lots, because I bought half of an interest in a vacated alley. But according to the property description, the previous owner transferred any and all interest that they owned. Well, they owned it all. It didn't delineate half of that. I'm sorry, I'm going off on a tangent here. But weird stuff happens. So the whole parcel number versus legal description, they're 2 different things. The lot numbers will stay the lot numbers. They might get a parcel number across 6 lots or a parcel number across 3 lots. However, anything that transfers from a legal description standpoint goes back to 1860 of how they described it back then.
Yeah, the Lucy Depp subdivision is very similar to this with the narrow lots. It's a historical site
Yep.
where freed slaves lived, and everybody had a very narrow lot exactly like this, because there's people I know who own some of those lots now, but they cannot build on it.
Yeah.
They cannot build a house on it because it's so narrow.
The smallest I know in Lewis Center is this weird one that's not on this old plat, but it's been split. And it is, if you go north a block, a lot, so across the street, go west now, the other way, sorry. See that little half lot right there?
No,
That little sliver of a lot?
keep
Oh,
going, right
there you
there.
go.
Okay.
It's very tiny.
So, gentleman last name Van Loon, he owns 2.5 lots there. The lot right next to that sliver is, got a structure built on it, that we call affectionately the shack. Because when we first moved in 22 years ago, nobody was living there, it was uninhabitable, etc. Somebody's put a lot of money into that, and it sold, 6 months ago? For $280,000 to buy down that tiny lot. That's the smallest lot that I am aware of in the entire village that has a house on it. And that's probably a lot and a half. So they split from the old plat. They took a half a lot. Mr. Van Loon kept half of that lot, and the other half a lot went with another single lot. So that's a lot, 1 lot and a half that has a house on it. And it's what you would consider a tiny house. But that's the small, just to point out, that's the smallest build that's currently there. The smallest available build, unless you bought an individual lot, is that 2.5 lots that Van Loon owns. Everything else is owned by common owners now. So you know, 3 lots that I'm purchasing owned by us. The 3 lots on Franklin Street that's right in front of it, owned by a single owner. All of the individual lots that are probably buildable lots on facing Lewis Center owned by Mr. Richard Ball, who sued the county when they took part of his land for the roundabout. Because he didn't get equal value allegedly from what Evans Farm got value for their lot or land. But that's the smallest build, is that lot and a half, 1 lot and a half lot, right there, that we have.
And one thing I want to point out too, and going back to the lot combinations, so under the current zoning FR1, the minimum lot size is 1.98 acres. So these lots are what, 0.25 acres at the largest. So even if you combine 6 of them, you're still under the minimum lot size for a lot, and you would have to get a variance to come in to even just combine the lots, and that came up at that BZA hearing as well. I want to keep talking about this. I do want to also kind of zoom out and look at Lewis Center Village as a whole a little bit. So I'm going to change the subject, I think, and then we'll kind of come back and button this up. Because one of the things, we're talking a lot about setbacks and lot sizes. One of the unique things about Lewis Center Village too is that there are some commercial uses here. And they, you know, they tend to be more up on the Lewis Center Road side of things. There's you can see the one large lot in the kind of southeast corner there, as well as a church. But there's the county EMA building, there's the kind of multi-tenant office building there. So there are some commercial uses. So the way we set this up in the text, when we kind of originally crafted this draft code, is we set it up basically almost as a mixed-use district. And I think that, you know, looking back at that and, you know, looking at it with some lessons that we've learned over the past few years, I don't know if it makes sense for the entire village to be kind of one mixed-use overlay. So what I'd like to propose is kind of breaking this overlay district into sub-areas. One which would allow commercial uses, kind of focus that on the Lewis Center Road corridor. And then the other would be a residential sub-area that would focus on the rest of the village. Because you know, in that southwest portion there, I don't think that a commercial use necessarily makes sense.
One of my questions is, back to the small lot sizes.
Yeah.
Did I hear that most of the lots, or multiple lots, are normally owned by one person, or?
So in general, most owners in the village own multiple lots. That's not universally true, but
But in
generally
general.
true.
Yeah, so, you know, I guess, you know, in recognizing that, what is that? Does that require anything unique that we have to do something? If a person already owns, you know, multiple lots and there are ways that they can build things on multiple
Well,
lots at one time?
again, it's, I think what we're trying to do is make this process a little more streamlined for the property owners in the area. And going through a variance process, which is a judicial process, is certainly not the most streamlined. And so that's why we propose this as an overlay, because it, you know, it still requires the public hearing. It does require them to come before, you know, a commission and invite their neighbors. So it requires that level of public scrutiny, but just the criteria for approval is perhaps a little less stringent than a variance, which is based on hardship. And I think there are good arguments for hardship in, you know, in this area, but again, just trying to make it more streamlined while still, you know, requiring some rigorous review. So it's just trying to strike that balance. So again, as I've looked at this over the last few months, Mr. McCoy came to me about this, 6 months ago for the first time, and you know, said a lot of the same things that have been said during public comment tonight. I tend to agree that in this draft that we have currently, we probably want to look at revising some of these setback numbers in particular. And I do want consensus from you all that, you know, that's the direction that we should go, that, you know, maybe trying to find whatever creative ways that we can to respect the character of the village, while still removing some barriers for property owners in that area.
Have you gotten any feedback from anyone else in the village with similar
No, I have not.
concerns? Okay.
I'm in pain.
You know what?
I'm the pain.
Yeah, I hear you.
But I'm also sort of unofficially, sometimes the village voice. And
Well,
my thing about the variance is, yeah, a lot of these variance requests can be eliminated through wording that Robin and you guys have already put into this, like across lots that you already own. But if you're down to, if you can take it from 13 variances, you have to get down to, oh, you're asking for 3. I think that is a step in the right direction that also then protects adjacent landowners and eliminates some of these things. In a perfect, I don't want to say it's a perfect world, because I don't wish it to happen in my lifetime, But maybe sometime eventually a developer comes in here and they they buy out the whole place, they wipe it all out. And then they're coming before a committee like this or BZA to ask for a complete rezoning, based on what you change. And all I was asking tonight was to take a look at it and maybe not go from the extreme that is the farm residential that you need to own 1.9 acres to build anything on, to, hey man, build whatever you want as long as it's 6 feet off of the property line. There's probably something closer to the 6 foot, way far away from the farm residential, but not 6 feet, that makes you come in and ask, and prove your point. Because I think it's pretty simple. Even the guy that built, or still building, he's been building that house by himself pretty much for 2+ years. It's great to live by when it's constant construction. But he was respectful in the sense that he really came in, and wanted to build something consistent with and complementary to what was already there. So it's a ranch. It's a very high ceiling ranch, but he also set back from the property lines 20 feet on one side and I think like 17 feet on the other side. He didn't try to fill all 3 lots that he purchased with a bigger house and get as close as he could, because he could have asked for that, but he didn't. And that's kind of what that I, am asking to try to eliminate, the free-for-all that could occur. Have some structure to it. It's not onerous, but yeah, maybe you gotta come and get a variance, but you only gotta get a couple because you have some unique circumstance that you want to accomplish.
When we had the open houses, there was a handful of residents from the village, and they shared similar concerns. It's a challenge to get anything through, but at the same time, we want to keep the integrity of our neighborhood. So just maybe we can go back and try to find a balance with all of it.
Because the best way to get a variance is to almost be forced, and I hate to use the word forced, but be encouraged to go talk to your neighbor, that maybe you've just bought the lots. Go talk to the existing neighbor. Hey, how long you lived here? 20 years. Hey, I'm wanting to build a house. What do you think? Sometimes those conversations ease over things rather than going, hey, I'm going to pull this drop down zoning that allows me 6 feet, and good luck arguing against it, because this is what the zoning commission said was okay. And I understand there's still a hearing, but it's harder to argue against something when you've kept something so loose in terms of dimensions.
Yeah, it's a hearing, and it's a different set of criteria,
Yeah.
right? Okay, so, the BZA is the hardship factor, and this is, I don't know what page that's on.
And under the kind of, in addition to the variance aspect, because under the nonconformity section as well, so there's kind of multiple things at play.
My whole point is, if you allow it, somebody will do it. And if they don't have to ask, they won't. And I would like for them to, if they're gonna really do something extreme, to have to ask a little bit when they get too close. So whether that's physical living structure or, somebody gets a patio 6 foot up to a property line, I don't care. I just don't wanna look out and go, oh, you're in your bathroom, and their window's right there. But I appreciate your guys' time tonight. I'm sorry I'm long-winded, but Robin's had to listen to this multiple times. Erica has had to listen to it ad nauseum. Not me complaining, just concerns. Thank you.
So Robin, now that we've sort of had this history on the Lewis Center Village, what is the zoning code proposing?
Well, so currently, this is the proposal that, we haven't altered or edited this in the last few months. So this has been the proposal for some time. Again, I'm willing to go back and revise this. I think particularly looking at the setbacks, there is a lot of text in this district, because it's an overlay district, a lot of that has to deal with the procedure, which we'll also iron out. But one big change would, again, be kind of going into sub-areas that would be a commercial or mixed-use sub-area, and then an entirely residential sub-area. And then looking at those setbacks, trying to figure out the magic numbers I think particularly for side and rear setbacks, and looking at different setbacks for accessory structures, trying to, again,
Versus
just
the
find
main.
those magic numbers.
Yeah, so that was one question I had, because I agree, I do think, the area along Lewis Center Road could be a mixed-use area of either, right now, it seems to be a mixture of housing and or commercial, and I see no reason why it couldn't stay that way.
Yeah.
The area to the south of that, I think should stay residential.
Yeah.
So then the only other question, I was looking at some of what's permitted and what's not permitted, and that's what I wasn't sure about, because some of the stuff you have accessory uses like a private parking lot, well, technically, some of those businesses have private parking lots.
Right.
So I would assume it would be a conditional use, not a,
Yeah, and we'll have to, once we split into sub-areas, we'll go back and take a look
and
at
take
that
a
use
look at
table
that,
as well.
okay.
Yeah.
And so, and if commercial is allowed, I would have no problem with having a restaurant or something like that.
Right.
Yeah, sorry, just a note, so I know the uses are in each of the districts, but it seems like forever, I don't even know what meeting we did, but we did go through them all, and so that will, with the changes that, we talked about,
Yeah, they have
Months
not,
ago.
they're not reflected in this.
Yeah,
current draft.
yeah.
Okay, all right, so I was just wondering about that, because, yeah, like I said, if this is sort of mixed use, I wouldn't mind seeing like a restaurant that maybe sold beer or wine or whatever. I wouldn't necessarily want a liquor store, but, what? But, I guess so, more like maybe a convenience store.
Right.
A mom and pop, restaurant.
so how does the board feel about this overlay district, like as the process
I
goes?
think that's fine. I think, Robin, you should do whatever makes your life easier with respect to all the divergences. Whatever you can cut those down is good. My personal opinion, if this property is less expensive than other property in Orange Township, somebody's gonna come in and buy this whole thing. 10 years, 15 years, I have no idea when, but sitting across from Evans Farms, that's going to happen, and we'll rezone this whole thing at that point in time if and when that occurs. Be past my lifetime, I believe, I know, but.
Yeah, and I think that brings up a good point too, which is, assuming that an overlay district is passed in this area, they will have that option. They can also always request rezoning to another district, should they choose. I don't see that as particularly likely in the near future, but.
Not near future, no,
Yeah,
not
but
near future. That's
it
just
could
gonna
happen.
take care of things, make this simpler for the near future,
Yeah.
whatever time period that
I
near
would
future is.
throw in the caveat of trying to maintain its character.
Agreed.
I would agree
Yeah,
on
I
that
think-
one.
Because what I don't want to see is, like you mentioned, is someone buying 6 or 10 lots and then putting a couple McMansions on it, nor do I want someone buying 6 or 10 lots and putting a big apartment complex on it.
That one I don't want to see.
That, or a big townhouse or something like that.
Sure.
So however we could try to maintain the character with what we can do with the zoning overlay, I would strongly encourage.
Can you request divergences in this overlay?
So I was gonna hit on your two questions.
Okay.
So overlays can include a divergence process. You can, it's a bit of choose your own adventure. You could prohibit any divergences. You could limit divergences. You could say you can request divergences, however, you can't request divergences for these specific items. So in terms of, those particular, height or I mean, a height would be a good one, quite honestly. You know, that would prevent a situation of, if most of the, you know, houses in the village are a specific height, preventing a divergence on that would be one, just example of that. But, so as long as it's whatever you put into the text.
And if it was open-ended, the board would be able to deny it based on the amount of, like, the
Correct.
divergences are kind of open for negotiation.
Yes.
But if an application comes in with everything, if in full compliance, it's very difficult to deny, so. But with the divergence, that could be,
That gives the opportunity to deny, because it is something that's outside of the standards, and, it gives you the opportunity to deny an application.
And I'm just curious on, I mean, the story is that it has historical significance other than, I presume, I don't know if it has historical significance.
no, I don't think anything is
Not
there.
necessarily.
There's a couple of old buildings, but I can't really say that they're earth-shattering. The only statement I could say for historical significance would not be architecture, but actually under history and culture as a small railroad stop farm community type thing. But architecturally speaking, I don't think I could make a case that it's architecturally significant, but more culturally significant.
You'd have to have the state intervene and say, here, this is significant,
Right.
and write a law to it for it to be.
Oh, no, you'd have to put it on the national register.
Exactly, you would have to put it there
So,
for it to be protected.
for the state to recognize
Yeah,
it
for it
and
to
to
be
be protected. Which does provide protection from federal and state projects. And I'm not saying that we should necessarily put something in our zoning code to deal with historic districts, because
No,
it
thanks.
creates a whole can of worms that I do
Yeah.
not think our township wants to deal with.
No.
From my experience, I'll just leave it at that.
So, I mean, how do we, if we do allow divergences, do we limit it? Is it open-ended? Do we not allow them?
I say none.
You say none?
If the story is we're trying to preserve, right, what they have and what they're doing, then you have none.
And because of the overlay, that we should have no divergence.
I would
And-
have to see how the overlay was
I
written.
know.
That's my biggest thing before, whether or not
Yeah, we should wait till the rewrite that Robin's gonna go back and look at.
Well, those all have to show up before BZA. I remember one we had a few years ago, guy wanted to build an auto repair facility, take over 3 or 4 lots, and here for a couple of meetings, and we eventually said no again because of that character. So those things still have to show up before the BZA, I think, and
Well, this would be zoning commission, not
zoning
BZA.
commission, okay, so still have to show up before somebody to make decisions about.
Yeah, and, if the consensus is no divergences, I mean, we can look at that. My recommendation would probably be to allow for at least some, because this is all theoretical in a way until the rubber meets the road. And having that kind of, that outlet valve, that pressure release valve in the form of allowing a divergence if the governing body thinks that's appropriate.
Yeah,
Can be
we can limit it, and then if whatever they propose, we can still say no to.
The typical old way we got out of
Yeah.
that is, hey, this is grandfathered in. And we were pretty much done with it, and it was Lewis Center, and we kind of had that attitude and viewpoint anytime anything came up for Lewis Center.
I would also say, because the underlying zoning will still stay in place, that even if, divergences in the overlay are prohibited or limited, that the property owner would still have the opportunity to request a divergence. So I could see a situation if it doesn't
Can't get it
meet the
here.
criteria of the overlay, again, they still have to go somewhere for approval. So there's still the opportunity, to have their hearing and argue their case, but also to, be denied if it's just not.
I agree, I think that flexibility always has to be left there when we're talking about Lewis Center. Has to have some flexibility.
It's tough.
And this is very new, this would be a first for the township. The township has never done an overlay district that the final decision is laid with the zoning commission. So, that is what we're proposing, the 23 overlay, district. The final decision, is with the trustees. The trustees would not have a part in this.
And to your other comment, Michelle, on
Really,
6.16, that was something Robin and I talked about. I think that was just left, that
Okay,
should
yeah,
say
that's
zoning
fine.
commission. Yeah.
Yep, so that, it's new, and, you know, obviously, this has to go to the trustees. If they think otherwise, it could be changed, but that's what we're proposing. I mean, you guys are the experts, and we believe, you know, a decision like this can be made here.
Yeah, so I think,
Thank you very much.
I hope I don't get,
Robin, I think after you come up with your proposed story, then let's revisit
Sounds
it.
good. Yeah,
and
we
let's
will.
try to test it and run through some scenarios to
Yeah.
make sure it makes sense.
We will come back with some revisions
Yeah,
for you.
and then we can go over the permitted and conditional uses then,
Yeah,
the
and so, and
setbacks.
that's actually something that because originally we had this as a straight district, I don't think, we talked about this, I don't think there can be conditional uses in an overlay district. It's
Correct.
either, yeah,
Yep.
so
Okay.
we do have to redo that chart, just for no other reason than for that, because you know, it will either be overlay or not, there's no conditional.
Okay,
okay, that makes sense.
all right. Anything else with Lewis Center Village?
Can this overlay, somebody comes in and says, I want to use the overlay, Lewis Center overlay on this new piece of property somewhere else. There's restrictions and that couldn't be done.
No, it is geographically targeted, so
Okay.
there's actually a
Thank you.
map in there that shows which parcels it can be applied to.
Thank you, that's important.
Which is one of the reasons, again, I know a big policy decision is how do we deal with these existing small lots without creating a scenario where someone could split currently farmland into a bunch of different lots. That's another reason why staff went more the overlay route as opposed to a straight district, because if you had a straight district, then someone outside of historic Lewis Center could theoretically rezone to that district. And again, because this is an overlay, it is geographically contained.
Contained. Perfect.
Yep.
Thank you, ladies and gentlemen.
Thanks.
I'll probably see you training on Thursday for BZA.
No training, but we do have BZA.
Surprise! I was like, I don't think I have this on my calendar.
That's usually my reaction. Thank you.
Thanks.
Had a heart attack there.
Okay, so, one district down. That is probably the most complicated, of the districts that we'll have. But we'll get through a few more tonight, if we can.
Cool, I'll put it up, keep going.
And it's not just me this time.
All right.
I feel like I'm with it, Jack. It still comes.
All right, so we are moving on to farm residential, which is FR1. So this is a currently existing district. You know, we have FR1 properties. So this would not be a new district. We're just proposing changing some of the development standards. In general, things would get a little bit more permissive. So the lot size currently is 1.98 acres. We're proposing dropping that to 1 acre exactly. That would bring us in line with Genoa and Liberty Townships. Their FR1 is
Okay.
precisely 1 acre. It just makes it a little cleaner, although sometimes I do feel like I get to sound very smart when I say, somebody asks me, what's the minimum lot size? I say 1.98 acres. So I won't be able to do that anymore, but it makes things a little easier. Again, it would be, you know, the same kind of rural lot, you know, not really meant for development, but it would, you know, allow for single-family homes on these large lots. It would probably allow for some large lot owners to be able to split their lots a little bit more easily. So that's something that we should be aware of.
So what is currently, and I don't know if anybody else knows this, the health department, what do they require lot size if you're on septic? Is it, because I thought it used to be 1.9 or around 2 acres?
There,
I don't think well, just because of Lewis Center Village,
Okay.
Yeah,
I
to
don't
my
know.
knowledge, there's no lot size as long
think
as
it's
it's
just
big enough to
distance,
fit,
yeah.
you know, a dwelling and,
Okay, because I thought it was based on, how much land you have to support that leach field for your septic system.
I am quite confident that there are properties in Orange Township that are on septic that are smaller than 1 acre.
Well, yeah, but that's because they've been grandfathered in. When we weren't heavily, like, we could not do Lewis Center today through the health department. They would be required on SOAR.
I can look into it.
Yeah,
Okay. I just wanted to make sure that our size and what the health department requires, somewhat mesh, if that makes sense.
we can look into it. Frankly, it's not something that I had considered.
Okay.
So I guess you're open to that, a smaller, as long as it in
Well,
compliance with
I'm just
the
concerned
septic
that all
stuff.
this, well, I guess, maybe it's not a problem. Maybe, I was gonna say it'd be nice if people could keep their septic system, but if they wanna develop and lot split their 5-acre lot, someone else will have to pay for the sewage, the sewer to come there.
Yeah.
So maybe it's not an issue. I just know that, it seemed like in the past, when new subdivisions came, sometimes people were required to go on, sewer, and they were not happy about it.
Yeah, and that would, I mean, that is a reality that is outside of zoning, that there, and there are other approvals that people have to seek, and they do have to meet both the zoning requirements and the health district requirements and the building
Exactly.
safety requirements and,
I'm assuming, I mean, knowing that Genoa and Liberty have the same lot, I'd like to
They
think,
think that
yeah, but we can double check.
Okay, that was just a question, because like I said, I know, like some of the old houses on Old State, when the neighborhoods came in on what was originally farmland, some of them had to be hooked up or connected to the county sewer, where they previously had septic systems because of the buildup. They didn't have there was too many people.
I know in Franklin County that it could be you could build a brand new, home on a small lot like this, and as long as your septic system fits, that's okay.
Okay.
But obviously, Franklin County and Delaware County are completely different beasts, but that would be interesting if.
Yeah, just like if you have a property that has a septic field and you want to enlarge that house, you have to get permission if it includes enlarged kitchen and or bathroom, because of the increased demand on the septic field. So,
Okay.
yeah, that's the only area I'm at. And then the other question I have is, so if you're 5 acres or more, you're automatically considered agricultural, and then setbacks don't apply to you?
so it's only, the township has the ability to regulate, the township does not have the ability to regulate agricultural buildings on lots larger than 5 acres.
Okay,
That doesn't mean it's prohibited necessarily on lots smaller than 5 acres. Julie,
Okay.
you wanna?
And just because you have a lot that's 5 acres and you've got a residential home, you wanna put a residential home on that does not mean you're exempt from zoning. Again,
Okay.
the agricultural use and agricultural structure is the key,
If you wanted to build a barn on it, then
exactly, if you just have 5 acres and you wanna put a house on that, you are subject to, I'm assuming it's FR1 and you're subject to the
to the
district's.
setback, but if I wanna put a barn on 5 acres, then I'm,
Well, and
Not
so it depends on
subject.
what it's used for. If if it's a barn for livestock, then yes, you are exempt from zoning. If it's a barn for your classic car collection, then no, it is not exempt from zoning.
It again, it really does have to be tied to
agricultural.
agriculture.
yeah.
So if it's like a different thing from like a she shed versus
Yes.
it's a
Yes.
produce stand.
Yes,
Okay.
people like to get creative too.
Oh, I'm sure.
Cultivator for the cannabis.
Yeah, that is different.
Agriculture. Like, for
For my
purposes of
John
zoning, that's not,
Deere
that's not ag.
harvester.
It's agriculture, Robin.
I'm sorry, all right. Those are my questions when it comes to farm residential.
Right. So I have on the slide, the setbacks will be decreasing in general. So the front would be 40 feet. Currently, the front setback is determined by the type of roadway. So depending on the type of roadway, it's a decrease, but it would depend on how much. The setback would decrease to 15 feet from 25 currently. And then 30-foot rear setback is what we're proposing versus a current setback of 80 feet in the rear. So those would drop, again, to reflect that smaller lot size.
Yeah, and again, similar to Lewis Center, I mean, there's most of the FR1 lots, even outside of Lewis Center, do not have a hard time complying with the existing setbacks, so.
We've already gone over the uses on this in the use table. There is one thing that I want to call out in FR1, it's generally a single-family residential zone. Currently, our FR1 is set up that religious institutions are only permitted in FR1 with a conditional use through the Board of Zoning Appeals. And religious institutions also have unique zoning regulations which are outside of the scope of really what we're able to regulate. But we are proposing that religious institutions would be allowed in farm residential by right and would not have to get a conditional use from the Board of Zoning Appeals. So that would be a change.
Makes sense to me. I'm not opposed to that.
That's most of what I wanted to talk about on FR1. Any other?
What do you mean by private garage?
That's something,
Yeah.
I think that's on our list to
yeah,
clarify, right?
I'm still working on that one.
Yeah.
Yeah,
Okay.
we had that
Because-
discussion in the use table.
Yeah.
All right, because I have no problem if they have a detached garage, but I don't understand what a private garage is. For their car collection, they should be able to have a detached garage.
Yeah,
But if that's considered not leasing parking spaces in said garage, but just for personal use, so.
I think we had the discussion about it being like more of an accessory structure as opposed,
yeah,
Okay, because like I said, I wouldn't have a problem with a detached garage on a farm residential
Yeah.
lot. Nor would I have a problem with a kennel if it was limited.
Right.
and kennels, it could be agriculture now?
There's case law that says that kennels are
Yeah,
ag.
so that's just something we have to keep.
Kennels or what?
Could be
That
ag.
kennels qualify as an agricultural use under that zoning exemption that we kind of.
Yeah, so I don't know how much we can limit it, but,
Okay, because right now it's not permitted at all
oh, okay.
for farm residential.
Is that a
And
problem?
I know that we've got a note in the use
Okay.
table that basically was like kennels need to be, that just needs to be reworked.
Okay, so I would just, like, the private garage for the farm residential, like I said, I would look at the kennel as well.
Okay,
I mean, I'm not talking to like 50 dogs in a puppy mill, but,
yeah.
But if that's in Ohio law, can that be regulated by the townships? If the kennels are allowed by Ohio law?
So if it is a lot that is greater than 5 acres, because kennels is considered animal husbandry, which is under the agricultural definition, township doesn't have the ability to regulate the use or the structures that kennel for a property that's over 5 acres. There are ways that the township can limit to some extent for properties that are between 1 and 5 acres and under 1 acre. And I believe that your zoning resolution is consistent with the law. But in general, on a lot that's over 5
Over 5
acres, you
acres,
can't
no.
regulate,
Yeah.
yeah.
okay,
That's what I thought, that's
so
Ohio
if
law.
I'm farm residential right now, can I have a kennel? All right.
Yes.
With this new one, can I have a kennel?
I think that's on our,
Part of it.
Okay, if I'm farm residential right now, can I have chickens?
yes,
With this new code, can I have chickens, sorry, not kitchens, chickens.
You can have kitchens and chickens.
Or goats, or,
I think so, yeah, yeah.
okay, all right, that's just what I wanted to know. Because it sounds like, you know, I know if I have 5 acres, that's definitely the case. But if I'm farm residential right now, and I'm allowed to have, you know, goats or llamas or sheep or
I think you
whatever.
can have, well, in a lot of even single-family districts, if you have the space in your yard, I believe you can have chickens. I think it's more of an HOA regulation at that
Okay.
point, so, yeah.
Okay. All right.
We have been getting an uptick in
Request.
queries as to whether I can have chickens in my backyard.
Egg prices are through the roof.
Oh, yeah.
Yes, yes.
Of course.
But that is a thing.
Not for me,
I
I'm
think
allergic to eggs, but anyway.
Yeah, I think it's just a HOA
Okay,
thing more,
so I just
so.
wanted to make sure, like I said, because I know there are still some properties along Old State or in some areas that are considered farm residential, where people
Generally,
have livestock,
Yeah,
you know, I don't know, chickens, goats, whatever they have. So I just want to make sure that they can still keep said livestock.
And I know, I'm like, I've got a note in my binder from, I can't even remember when we talked about this section, but the changes in the standards are not going to create any non-conforming lots right now, because you're reducing the restrictions and you're not expanding the
Yeah.
restrictions, so that's
Okay.
a benefit.
as well as, I mean, uses too, for what we know. We shouldn't.
Is there anything else that we need to know about the new farm residential?
I have nothing.
Okay.
All right. Article 8 is campus institutional, and this is a bit of a leading question or leading discussion. So initially, when we drew up this zoning draft, we had envisioned, rezoning all the properties in Orange Township and making a zone, a campus institutional zone for kind of public and semi-public uses. So schools, utilities, churches, things like that, that would fall into this campus institutional zone. So we designed it with that in mind. However, since we've kind of retooled our approach, we're not going to be rezoning properties at the outset. I don't know that it makes sense to keep this in the draft, because, if you have a school, are you going to go through the trouble of rezoning your property to campus institutional? I don't know that anybody's going to go to that trouble.
So what are the advantages of having a campus institutional zone?
I think that's the problem we're
Yeah.
having.
At this point, there isn't one.
If there isn't one,
Yeah.
then
Yeah.
why have it?
I think our consultant, suggested it, but because all of that falls into the commercial, it's just almost a waste of text.
Or residential conditional
Yeah.
use?
Yeah,
Yeah, and I think our idea behind it was to be kind of even less restrictive on the campus institutional side, that if it's, again, going back to a school, that if you have kind of a designated zone for schools, that you probably are going to be a little less restrictive on a school than you would be on a commercial business. And so that was the goal, was to have something for them. But, again, I don't know that it would be used that much, because a lot of those institutions are in place already.
I
And,
mean, when I don't remember Olin Tangi ever showing up anywhere. They just.
right, and that's
got
the other
property and
thing
built
too,
it,
is truly,
And we didn't
you know,
have any say, it was already done.
truly public,
Done deal,
generally speaking, other public entities don't necessarily have to strictly follow our zoning
Right,
regulations.
exactly, so no point.
Just like OSU doesn't seem to, in a world
And
unto themselves.
Olin Tangi didn't either.
So,
okay, so no need?
I mean,
unless, Michelle, Robin, you think that there's need to have it. Like I said, if there's no advantage to having it,
What was the original thought for putting it there again?
Well, again, so when we first started this project, we were envisioning taking every single property in Orange Township and we were gonna drop them into these various buckets. And so we created this bucket to drop them into, but now we're not going to change everybody's zones.
Oh, okay, yeah.
So,
Yeah.
Yeah, so there's no, yeah, no sense in
so if I remember correctly, the
listing it, yeah.
trustees did not go for that idea completely, so.
Yeah, and I mean, I think a lot of parties, I don't wanna.
Yeah, it was-
It's difficult.
I'd say logistically and legally
Yeah.
difficult.
Well, let's not make life difficult,
Yeah, let's just,
yeah.
All right, so no more zoning districts at all.
well, that's easy to go through.
Delete.
All right.
We're making it shorter, Arn.
It's not.
Okay, so next up is Article 9, which is community living. So that is designed to be our multifamily zone. So again, we set this up specifically for multifamily. So we, as a reminder, we would not, this would be a new zone, but we are not rezoning properties to this zone from the outset. It would be that property owners down the line could request rezoning to this district. But this would be a straight zoning district for multifamily. So, and I think this also may need a little bit of tweaking. Frankly, when we first did this, I kind of look back and I'm like, what were we thinking there? So some of the numbers may need to be tweaked. We had 10-foot setbacks for side and rear, except where it abuts other residential. I think that can probably be bumped up a bit. We had a 50-foot rear setback where it abuts other residential. I think that's similar to how we have our 100-foot buffer from commercial properties to other residential. I think that could go up to 100 feet to be in line with that.
So this is strictly multifamily as opposed to sort of a mixed use?
Correct, yeah, this
Okay.
would be
Yeah, because that's a different.
residential.
So that would be a
District,
different
yeah.
district. So this would be just for like, I hate to say apartment complexes, but,
Right.
okay.
Townhomes.
Townhomes, senior living also
Okay.
could fall into this, assisted living even.
Are we having, what are they called? Not necessarily group homes, but like, almost like campus-style living. For example, by OSU and like in downtown, they have apartment complexes that have like studios, but they might not have kitchens in them, and they have a community kitchen.
I mean, we've never received a proposal to like that. Yeah, and I know they have some of those downtown. I can't remember what that's called, but it's like the shared, like,
It's like a, yeah.
the shared spaces, but everybody has their own like bedroom, bathroom kind
Yeah,
of thing.
everybody has
Yeah.
their own bedroom, bathroom, and maybe something, like that, but they might share certain spaces or
I
something.
don't even know.
I would call that a dormitory, and
It's somewhere between a dormitory and a group home, I don't know.
Something we should we add that to the use table?
because
Because I don't think we have
there's no,
that.
I was like,
I
there's no,
don't-
I don't see a definition.
I don't
for it.
know if there's a use for it, the only reason I bring it up is
Yeah.
because we have the DACC and the, other community college down the road.
Yeah, well, they have them in downtown Columbus. It's like, I think it's right by,
There is one,
Thanks.
like exactly what you say, near Marion, OSU, like across, so the bathroom will be shared, I mean, like they will have a attached bathroom and bedroom, but the kitchen will be shared in a common space. Yeah, that comes under actually the multi-apartment.
I just, how would you regulate that? Or is it still just by, like, is bedroom the unit?
Yes,
I know I've seen language that deals with, again, dormitory is the phrase that comes to
Yeah.
mind, and the kind of like shared communal space.
Harlow Apartments? I think that's what it
There's
is.
Harlow is one of them.
Yeah, that's the
one that's
shared.
downtown, that
Yeah.
has shared space.
What do they call it?
Yeah, I'm
I don't
looking at
know.
their
I
website.
think
What you're looking for is
Excuse me?
co-housing, I think is the term you're looking for. They're very popular around the Boston area.
What is it
No.
called?
Co-housing.
Co-housing.
Oh, okay.
Cohatch
Um,
business.
where people will have their own detached dwelling units, but rely on, like a common dining hall, kind of a setup.
Co-housing.
Mark, would you mind saying your name
Yeah.
for the record?
Mark Freeman, 478
Thanks.
Glenside Lane, Powell.
Thank you. Yeah, Julie, I'll send you what we're talking about, because
Thank you.
I don't know how that is addressed.
Yeah, I think,
Yeah, I don't necessarily think we have to worry about it right now, but if it's something that, like I said, down the road, there's DACC and there's that other,
No,
Branch campus.
I mean, I think they're designed to be an affordable option,
Option,
so.
yeah.
I think that's the place that comes up is
Yeah.
affordability.
Yeah.
yeah.
Now, that's where this makes these more viable for the future, not just for schools.
Yeah,
Yeah.
Yeah.
I hadn't even thought about that, yeah.
There's a farm on Cheshire, a farm area on Cheshire going towards, east, where they have a big home, farmhouse with a large kitchen, and they have smaller little tiny homes that'll be kind of built out for people to live in on their property.
Oh, okay.
And then they'll use that shared kitchen. I've been there a few times touring it. It was on HGTV.
I like it.
I
It's
have
super nice.
Yeah, I like it.
I have
I've toured
an old
those,
friend
yeah.
that lives in a, she calls it an intentional community, but it's like co-housing where you have your own house, but
I
you
like that,
also have
intentional
like a clubhouse, community kitchen, community room, so that if you have visitors coming and you don't have
Yeah.
room in your house, they can have a room and a bathroom.
We might all go to that eventually with cost of everything.
Yeah, with the affordability is the big thing.
yeah, so, and just reeling it back in,
Oh, yeah.
so.
Yeah, thank you.
I don't want to get too off track, but actually, that's going to be probably a good segue into the next district, but I do want to stick on community living, because we're going through this discussion, I'm realizing we don't have a specific definition for dwelling unit, so I made a note to add specifically what that is, because I don't think that the type of living that we were just discussing necessarily falls into this community living zone, but it can possibly fall into the catch-all, which is our planned unit district. So we'll get to that in a second. But I do want to focus on community living for now. So this, again, designed for, we'll just say traditional multifamily at this point. The building height, we're proposing at 40 feet. I know, we did have a proposal for multifamily recently, and building height was a sensitive topic. So I don't know if you all have any thoughts on that. The commercial building height traditionally is 50 feet. Kind of single family and even two-story residential is typically 35 feet. So I'll particularly lean on my architect friends.
Okay,
What do we think of a 40-foot building height? Should it go up, should it go down?
So the question I also have is, in some communities, like City of Columbus, they look at building height as the average. So if you have like a gable or a hipped roof, it's not at the peak, but at the sort of
Yeah.
center line or the median.
I think we defined it in this new code, right?
Yeah,
How
so
we're measuring building height?
we did define it,
Yeah.
but it is to the highest point of the roof line. And part of that honestly is ease of administration, that I don't know that we are equipped to calculate the average of a building that may have 8 different roof
Yes.
lines.
Yeah.
Okay.
But if commercial is allowed to go to 50, what's our reasoning for not allowing a multifamily?
So multifamily generally, these are 3 stories. Once you go to 4, you get code issues and you have to generally have a separation between your ground floor and your upper floors, which you can do if it's 50 feet, you can have 3, maybe 3.5 stories above a ground floor, so you can have a 4 to 5 story building.
Huh?
With this,
Well,
would
I
say-
just remember, we just had one across here that Delaware County Planning and Zoning and it was a 50-foot multifamily next to
To
some condos.
35
and
foot
yeah,
condos,
and
exactly.
it simply didn't fit where it was, and it got rejected.
Yeah, well, and I mean, our current trend right now with multifamily is height and density are the two biggest issues. So, you know, this code, let me take, our current code isn't even designed for multifamily. It's, I think, is it 35 feet?
Yes.
Yeah, it's 35 feet and the maximum dwelling units per acre is 4. So obviously, no one has applied for that district. That's why we consistently have planned districts, because no one can, just economically, you cannot have a multifamily district with 4.
4 really isn't a multifamily.
Yeah, and, you know, and 8 is even, you know, a lot of the proposals we see lately are the 10 to 14 units an acre, and, you know, I don't think Orange Township is ready for that, so we were looking to double it with our proposal. And, you know, with the height too, I mean, if we're only allowing 8 dwelling units per acre, I don't know how tall of a building they need to have, or
Yeah, and for historical context, the Schottenstein properties at the corner of Shanahan and 23, those were 35 feet. The apartments that were approved in the BJ's rezoning, which have not been built, but they are approved, those are at 35 feet. So those are the largest multifamily approved in Orange Township to date. They are at 35 feet.
5 feet's not gonna get you an extra floor.
Right.
So.
Yeah.
so it's either 35 or 50, really.
Yes, and so I would say maybe just keep it right now with 35 feet, especially if it's going to be a budding, single-family residential, but increasing the density to 8.
Yeah.
Like
And
you
so-
said, so it's actually more buildable.
And again, I do want to point out, this is a straight district that somebody can come in and just rezone, and these are the rules. If somebody wants to come in and build 50-foot apartments, they can do it through the planned unit development request that we'll talk about next. So there's that release valve if they don't want to go to this straight district.
Yeah, but I guess knowing that, right, we're not building any more land, there's no more land here. People want to move here. What's our challenge in having additional floors for people to?
Yeah, I think what I would suggest is, what is the zoning commission's vision for the township, or what they think is the most suitable might not be the same as the trustees. Quite frankly, it hasn't been lately. But, you know, your recommendation is reviewed and is taken seriously. So if you believe buildings need to be higher, we need to have more density, you know, that's something that the trustees can consider. I say,
Yeah, I mean, that's
this is the group to figure it out.
I think we ought to look at it practically. And what we've seen practically across here is Delaware County is allowing no more curb cuts on 23.
Yeah.
Okay, so you've got limited things, and especially the other thing that these big multifamily did was a lot of traffic, and no additional curb cuts on 23. You know, so there's a practical issue here that we are dealing with in Orange Township.
Yeah, and
So I am against raising the height for any multifamily,
Okay.
absolutely.
Yeah, and I think, Les, to your point, there is going to be a redevelop. I mean, a lot of the stuff that we're planning for isn't for the next couple years. It's gonna be the next 10+ years when redevelopment occurs, because there isn't a lot of land left. So, you know, there's not a lot, there might be 2 sites in the township that I can think this could fit in right now. So, it's very limited at this point.
Yeah, but so even with the limitations, I guess why not allow the developer to maximize the moment within the township? That would be my thought.
I wouldn't
Yeah.
do it under multifamily,
Nope,
I
I
would do
wouldn't
it under
either.
mixed use.
Yeah.
I would allow.
Yeah,
50
I mean, that's
under
something when we
mixed
talk
use.
later, if we do allow a 50-foot building in mixed use, at least we can try to assure that there is gonna be a commercial component to it. So maybe that's the compromise of,
Yeah,
of
because I
that.
don't see 4-story apartment buildings, but I have no problem with the 4-story commercial, hotel, or mixed use where the first floor is commercial, and the next 3.5.
Yeah,
apartments.
As you say that, Christine, I do want to clarify my previous statement that, standalone multifamily, the highest has been built in Orange Township is 35 feet, but the multi-use buildings at Evans Farm, which do have apartments in them, are 50 feet high. So there is precedent for that in the township.
Oh, they should have been designed better. I'm sorry. Architecturally speaking. You've seen examples, you
Yeah.
understand what I'm talking about.
All right, so do we have any, I'm hearing a couple different things. Do we have a consensus on height at 35 feet, height at 40 feet, height at 50 feet?
35.
Yeah,
35,
I like keeping it at 35 for that, I do.
And the density is doubled,
yes.
okay. Which I know it sounds like a lot, but 8 units is not.
It's not that much.
Yeah.
Is there anything else that's a big change that we should know?
I don't think so.
I don't think so. Again, we might tweak those setbacks a little bit to increase them for that multifamily zone, but.
One question I do have in terms of setbacks, and that was one of the issues I think we had with that, like, 4-story apartment complex across from single family. Is there a way we can address?
You want like a setback, a larger setback
Or a
that's
larger-
abutting a single-family district?
Yeah, or a buffer, because generally the setback is only between commercial and residential. This would be between 2 residentials.
Yeah, so
It's
actually.
basically so like a
Yeah.
35-story apartment complex
Yeah.
is not like on the lot line overlooking someone's like pool.
So Robin did that, yeah.
Okay.
He's-
So we have it as 50 feet in there currently. I think it does make sense to bump that up to 100 if the
All right,
commission is.
It's, as long as there's a provision,
Yeah.
whatever you think works best. My only concern, like I said, is I don't want an apartment building overlooking someone's patio
Right.
and
Yeah. I
have
think
that
that's a
family be
valid concern.
uncomfortable.
Yeah. 100 feet, okay.
Okay. All right, and move on to the planned unit development. So, again, we're kind of, we're rethinking how we do planned developments versus straight districts. So, almost every proposal that has come before you all in the last few years has been a planned district, but it's been a funky hybrid planned district. And what we're proposing is a bit of a different approach. So currently, the way we have it set up is, okay, we'll take the multifamily planned residential district as an example. The way we have it set up now, somebody can come in, request rezoning to multifamily planned residential district. We have a limit of 4 units per acre, but they can request up to 6, but then we call it a divergence. So, okay, the request is this, but you're violating this. So it's kind of a hybrid between a straight district, which has regulations, and a planned district where you make your own rules. And so, again, the global approach is to have these straight districts where, hopefully you fit into one of those straight district buckets, but if you don't, then you can come in and do this planned unit development, and essentially, the property owner, the developer, chooses the rules, and then it is up to you as the zoning commission and then the trustees to say, does this make sense? And so it allows for a lot of flexibility. It allows for, again, that release valve of, maybe it's a use that doesn't quite fit into one of the neat, tidy little categories. Maybe it's a multifamily where if the density is, it's a hard cap at 8 units per acre in the multifamily zone, but they want it at 9, and they think, this is the best plan, has it at 9 units per acre, then they can come in and do it under the planned unit development. So, and this is not, instead of having single-family planned residential, multifamily, planned residential, planned commercial, planned industrial, all those categories that we have now, this is just one thing. And then they pick and choose what uses they want, what development standards they want. And it's up to, again, you as the legislative body, zoning commission and trustees, to ultimately say yes or no. And so because there's such a wide menu of options there, it is important that we, consider that and make sure that the review criteria that we have in place allows you and future decision makers to properly make those decisions and have valid reasons for those decisions. So, if you look at the text of this zoning district, I mean, honestly, there's not a ton there. It says that they have to have all the things that you're used to seeing. They have to have a lighting plan, they have to have a landscaping plan, they have to have a parking plan, they have to have a signage plan. They have to include a proposed set of uses, proposed, setbacks, heights, things like that. And then they submit it to you all, and you review it.
Yeah, I like it because it allows the flexibility of time change or what is
Yeah.
trends or whatever other things that may be going on or that.
Yeah.
It's something we should have done.
Yeah, that may be attractive to the town. Yeah.
Well, it's a real PUD. as
Yeah,
opposed to what
and we've
had
never
before.
had
Sorry.
a real, when I started here, that was my biggest frustration in zoning. I'm like, we have all these planned districts, but they had their own set of criteria and they had to follow certain things. And when I went to school, I was like, well, I thought there wasn't any rules. It was up to the applicant to propose to the commission on what, and then you guys work together on creating the rules within the district. So this is, do I think this will be used often? Sure. But is it designed in a more appropriate way? I believe so. But to Robin's point, I think the criteria is the thing we need to focus on the most. And then there is a minor versus major, which we don't have.
Yes,
Currently.
for amendments, yes.
Yeah.
So 1 thing, 2, an item, what is this, 10C6, proposed set of uses. It's in the second line. Such a set of uses shall only include uses that are permitted outright and shall not propose any uses to be permitted as conditional uses. I'm reading that and wondering, did that language anticipate that there would be basically a list of permitted uses in the district, which is not what you guys wanted? So I think that language might need to be tweaked, to clarify that.
Yeah.
I guess my question is there, what are uses that are permitted outright? And if the answer is, well, I don't think that that's what you wanted, that just, I think needs to be tweaked a little bit, if that makes sense.
In my mind, I don't think that's what we want because
Right.
I want to see the creativity of the
Exactly.
people who are coming in,
Yep.
particularly entrepreneurs or whatever it is that you can come up with, present it, and then we can make determinations within whatever reasonable limitations or our thoughts in the moment.
So the review criteria is just the 4 bullet points? Is that how I read
Yeah,
that?
and I think that could use some tweaking. I think, when we put this together, we took some of this language straight from the current overlay district that we have. And so I think tweaking those might be necessary. If you all have any thoughts as to, what the review criteria should be, knowing that it has to be somewhat general in nature, I'm open to feedback.
I think we should maybe look at other local PUD texts and see what their criteria is.
Yeah, because part of me tells me that there has to be some sort of unique circumstances, whether it's the site that they're looking at or the type of building or use that they're proposing, which means that it should be a PUD as opposed to like a straight single family or a straight multifamily or a straight mixed use, or why doesn't it fall under the standards of these other categories? In my mind, there needs to be a reason for that. Is it a difficult site? Is it a use that we don't have?
So can the criteria be,
Does that make sense?
yeah, no, I get it. I just, for PUD, is it because it doesn't fall in with the straight
Yeah, it can't
district?
reasonably be accomplished under
Yeah.
a straight district.
Let's have them point out why. might be helpful?
I can't think of, I don't think that, I think someone can ask. Someone can always ask. And so I get the policy decision of we want to gear you towards our straight districts and only use the plan PUD if it doesn't fit neatly in there. But, I mean, you could put that as, I think you could probably, well, it already says that, one of the purposes is it can't be accomplished under a base zoning district.
Yeah, but
I think someone could still apply, but I think it at least gives a bit more, reason to potentially denying it of, we're gonna deny it because we think it could be accomplished under a different district.
yeah, because my thought right now is, oh, I want more density, I want my building to be higher, I want, basically to make more money off my building. Therefore, I'm gonna submit it as a PUD and not as the standard multifamily, so I can have more units.
But isn't that our responsibility to say to them, no, we're not gonna do any of those things and good luck,
Well, sometimes we do and sometimes we don't. It depends upon.
I mean, but, maybe they have a good reason for wanting all of this other stuff.
I think, how about we try to elaborate more on the criteria, and maybe that'll give you, maybe we can all feel a little bit better about it, because, I mean, I think we do have to keep them a little open, but there might be some room for
Well,
improvement.
given the nature of this thing, allowing for a lot of creativity on the part of the applicants, I think it would be helpful to build in a more rigorous review process in terms, or notification process of adjacent property owners, and possibly even wider than that.
Yeah.
If somebody wants to do something really creative, it would be good to get more community feedback
Yeah.
by the people that have to look at it all day. Because if somebody wants to build,
Yeah,
say, some super dense, low-income housing where it's all studio apartments, but it's 100 feet tall and it's gonna be lime green,
I like it.
maybe people in the
well,
neighborhood.
let me pause. So, Mark and the board, that is unfortunately a state legislation matter. So as far as the notification process, as far as expanding that any further, that is up to the state to change the public notification system within zoning hearings. Talk to your legislators.
Is ours just you have to do a minimum, or is it a maximum?
It is a minimum requirement,
So-
but, and actually, the trustees have brought this up recently too, because, we want to capture as much attention as possible, but the challenge is the consistency. So if you do it for an application that you think is gonna be contentious for 500 feet, and then you don't do it for another one. So as much as, we're trying to be better with our website and Facebook and social media stuff, but as far as the legal notification system, it's hard to expand on if we're not always doing that, and that's, even past our time.
Yeah, that's good.
Yeah, unfortunately, so.
Yeah, and there are other ways that the community can find out.
Yeah.
Yeah.
that it
We've
exists.
already seen the reality of this. Unless it directly affects you, you're not showing up. If you think it directly affects you, you're showing up.
Yeah.
And that's the way the world works.
Unfortunately,
On every issue.
unfortunately, nobody thinks it's gonna rain at their house.
No, or it's usually after the fact. Why did you vote on that? And you didn't come to the meetings.
Yeah.
So,
I did have a comment for Article 10. So should we list the existing PDs in this article that
So we did, that'll be a question for Julie, but we did have that in an earlier section, and I don't remember which one it was off
Okay.
the top of my head.
Is that in the intro it dealt with?
Yeah, it might have been section 2.
I just wondered, the PDs that we have wouldn't they technically fall in Article 10? We're just changing the name of all of them to just a blank PD.
So let me ask you, this, because I think what the township did was basically, we've called them previously active districts, and, which means that someone can't obviously rezone to those districts. Would you like to, by incorporating or referencing those dead districts in here, to basically create an amendment process? Or I guess what would be the hope by referencing?
I guess in my eyes, I'm like, if our district, we now have a district that's just called general PUD, can all of those PUDs that we've created over the last several years fall into that? Because it's,
No.
No,
okay.
because
right.
they're, yeah.
Because they're existing, because we're not rezoning what we already
Right.
have, is my understanding.
Correct.
If we were, like.
yeah, I'm not saying this right. Because I know they're all their own unique set of standards. I just, because we're not having SFPRD, commercial PUD or whatever, I just didn't know if like that could all be bubbled into one PUD, knowing that they all have their own unique set of standards.
So.
But if there's something that addresses it earlier, that's fine. I just think for clarification.
I don't think it does. I think we have talked about how to change the
Yeah.
existing PDs.
Good.
You would have to you truly would have to rezone them from these planned districts.
But you wouldn't rezone to go back to, you wouldn't rezone to go to a general PUD, because a PUD is not, like, no one just has this text. It's always something more.
Right.
So, okay, well, I mean, I don't want to make it difficult, but I think the amendment process would be addressed in, like, the general standards, right?
Yeah, so Michelle, can you go to page 13 of that PDF that you're on?
13. We were at 133. Oops.
And I do think we need to add some amendment language in there, but that's where the previously active districts language lies.
I think, and this is a me problem. I just have a hard time with all these planned districts that shouldn't have existed in the first place.
Well,
Yeah.
understood.
Okay, well, as long as it's addressed in there, I guess that was the comment I made. Sorry that I went on a tangent. You know, I'm still passionate about zoning.
We're all passionate about zoning, which is why we're here at
Yeah.
8:30 on a
That's why we're
Tuesday
here.
night.
But I guess
Think-
what's been done has been done. We just don't want to
I know,
repeat it,
yes, yeah.
okay?
Whole learning, right?
Yeah,
All right, so what I'm hearing regarding the PUD is to look at the permitted uses language and then to look at the approval language to make sure that you all have firm review criteria so that you know how you're judging future
Exactly,
applications.
as to why they're using the PUD as opposed to, a standard zoning designation.
Yeah.
all right, we got how many, 2 more districts?
It'll be a couple more,
Oh,
but
great.
we're making good progress. Again, I do think the Lewis Center Village is the most complicated one, so I think the rest of the districts we can go through fairly quickly.
We could
Is there
do,
such a thing as, even in the justification of using the PUD, that you could, well, I guess that's would be part of your review, but where the commission could vote just at the gate and say, nope, your justification you've given us at the gate without us hearing all the rest of the
I mean,
dream.
frankly, you're able to do that at any time,
able to do
even
that
for the
right now.
applications
Okay.
that you're hearing.
Like if someone wanted to do something that, you
could
don't
say, no,
agree
no,
with.
this-
Yeah, you can just, I give you those sample motions, every time, and
Yeah.
you can do that at the beginning of the meeting if
Yeah,
you
yeah,
so
yeah, okay.
choose.
Cool.
yeah, I mean, I just hope,
I think we've done once or twice in the past of not gonna happen.
yeah. But, I mean, hopefully, you know, your reason that you say no is a little valid.
It's not arbitrary.
Yeah, no, I got you. I got you.
All right, do we have anything else that we want to talk about on the planned unit district?
No, I think we're good.
All right, well, those were the sections that I was hoping to get through tonight, and I was hoping it was going to take about 2 hours, and here we are 2 hours later.
Well, that's what I was gonna suggest, here we are 2 hours later. Is there any other, urgent business?
There is not, but I do want to
The
pick a
urgency
date
is to
where
get
we.
this done.
Want to pick a date where we can continue this conversation and continue this application to that time, date, place certain.
So, next week, so not next week, 'cause that's spring break.
All right.
Yeah, next week is spring break. Y'all, I will not be here. I will be in Virginia, but y'all are more than welcome to carry on without me.
How do we feel about an April Fool's Day?
Sounds like a
Hearing.
good time to meet you.
April 1st?
Yeah.
Yeah, I'm
Yes.
okay with that.
I,
Liberty Township, but I can try to get Jen or Pete to come, or if, I mean, I don't want to derail the conversation.
I mean,
Can
I
you
think,
do April 8th?
I could do April 8th. I can't do the 1st, but I could see if someone else from our office could come here, or I don't want to derail the conversation. If there are questions that come out of that, Robin and Michelle can fill me in, or we can look to I am open the 8th, so up to you.
Would we know if we had application on the 8th at this point?
yes, we do not.
Okay.
Yeah, my thought is the first, but it would be my first
Yeah.
preference, but.
Leave it to you guys, 'cause especially since it's, if you're just in recess.
Yeah, so, and looking at the next couple sections, I think they're relatively straightforward. It'll be in, Articles 21 and 22, I think is where we'll want you to, to come back in.
Well, Article 22 is right around the corner, or 21, excuse me.
Yeah, but if we could get through, let's see, how many more articles do we have between?
I think we only have like 3 more uses.
So we have commercial corridor, the neighborhood commercial, flex employment, mixed use, and neighborhood zone, so that's
Oh, five.
five districts, which shouldn't take us that long. We could possibly get into some of Article 21.
We'll just stop once it gets legally.
Or make note of our questions. for
Yeah,
the
and I do,
later.
I do that, so I can handle that too.
yes, general development standards will be,
That'll be one of the most, and signage.
yes.
Yes.
All right, so have we selected,
April 1st?
April 1st? Does that work for everybody?
Yes. Yes.
So can I have a motion to continue the discussion of the Orange Township Code rewrite to Tuesday, April 1st at 6:30 PM?
So moved.
Second.
Mr. McNulty?
Yes.
Mr. Bellis?
Yes,
Mr. Pierce?
Yes.
Ms. Foster?
Yes.
Ms. Zundar?
Yes.
Motion carries.
okay.
Want to send something out about that?
Yeah, we'll send out a
You
calendar.
always do, it
invite.
always
Yeah.
shows up in my calendar, thank you
Yes.
very much.
All right.
I love that.
Meeting adjourned.
Is there any more?
We have nothing further.
All right, meeting adjourned.